So here's another great question. Does both the trustee's signature and the beneficiary's signature get notarized? A trust agreement is a contract, and the contracts don't have to be notarized. But I suggest that you always get your land trust agreements notarized, at least one signature notarized, if not both signatures, trustee and beneficiary. I think it just gives the document much more validity. You don't ever want to find yourself in court on the stand and the judge asks you, Mr. Real Estate Investor, when did you set this trust up? And you say, 10 years ago. And the judge looks at it and says, well, how do I know that? There's just a date on the trust. There's nothing verifying that like a notary. So you can see it prevents anybody from accusing you of backdating a document, because there's a principle in asset protection called old and cold matters. And what that means is the older and colder your documentation, the stronger that document is. In other words, if you try to set up a trust yesterday and go into court today and try to argue that your property's been in trust and should be protected in some way because it's been in trust, that isn't going to fly. The judge is going to say, well, you just formed this yesterday, you did it to defraud your creditors, and we're not going to recognize the validity of it. But if you bring in a document that's 10 years old and was notarized 10 years ago, you can see that old and cold matters. It would be a much stronger document to present in court if you needed to. So always get at least one signature notarized so that trust agreement is time stamped.